So good morning, everyone, and welcome to our Wednesday morning seminar online. Today we're looking at the JCT Standard Form D&B 2016. This will be presented courtesy of Mr. Conor Ahern, Consultant Solicitor with Silver Law. Conor, you appear to have lost your slide view.
Apologies.
As always, if you have any questions for Conor, he's happy to take these. And he will happily take these questions at the end. So pop them into the chat box or into the Q&A tools in the bottom toolbar there. Without any further ado, Conor, I'll hand over to you and let you take the floor.
Perfect. Thank you very much, Julie, and good morning, everyone. Yeah, so this morning we're looking at the JCT Standard Form Design and Build 2016 form. We're going to look at some of the quirks in this version, and obviously some of the key elements that that everybody needs to be aware of. Obviously, as it is the design and build contract, it obviously there is a big emphasis on design. Do bear in mind also that we're looking at the standard form position, and obviously standard forms nowadays get heavily amended through schedules of amendments. We'll discuss some of the more common more common amendments also as we progress through this seminar. Okay, great. So we get started. Obviously, as with any JCT contract, the starting position is always the articles and recitals. This basically, sets the scene in relation to the key elements that are being agreed between the contracting parties. Now, so in Design and Build 2016 contracts, so Article 1 is fundamental to understanding how the contract is to operate and set out the contractor's obligations in the following terms. So the D&B wording is that the contractor shall complete the design for the works and carry out and complete the construction of the works in accordance with the contract documents. Now, notice the emphasis on the design of the works. Obviously, again, as I said, the design and build contract key point is that design element. We can contrast this with the standard building contract, the SPC form, which simply states that the contractor shall carry out and complete the work in accordance with the contract documents. So you can see, that emphasis on design is critically important. In the DB version, we discussed the employer's requirements also. At the second article, we're looking at the CPs, and the third article also discusses the fact that the employer has checked the contractor's proposals and is satisfied that they meet the employer's requirements. Key points, again, just in terms of setting the scene in relation to the DB contract, and again, it would be one of the areas that is commonly amended, in particular that statement, that third recital that says that the employer has checked the contractor's proposals and is satisfied that they meet the ERs. That is one that is commonly amended, as you can imagine. Just to compare, just as a means of comparison, in the standard building contract, if you're looking for the ERs, they are at the 10th recital and the CPs are at the 11th recital. Okay, moving on. So the contract documents. So what documents are actually included in our design and build contract? Well, if you look at clause 1.1, the contract documents are defined as the agreement, which is the articles of agreement, basically the articles, the recitals, and the contract particulars, the conditions, which is the main operative clauses within the contract, the employer's requirements, the contractor's proposals, and finally the contract sum analysis. Obviously, this can be amended by agreement between the parties. And I remember when I was working with a contractor, basically as a QS, I'd always try and get my schedule of clarifications in quite high up in this hierarchy, particularly if there was a follow-on hierarchy clause. Because that's where you basically want to get any of the assumptions or any of the any clarifications that need to be made in relation to the contractor's bid. That's where you'd really want to get them. So yeah, this is a standard list, but obviously, it's always good particularly if you are the contractor, you know, to include your schedule of clarifications within this list. In regards to this, similarly in the standard building contract, so the contract documents are the contract drawings, the agreement and these conditions, together with the ERs and the CPs, employers' requirements and the contractors' proposals. And if it's option A, you'll have a pricing document, or if it's option B, you'll have a specification, basically where the spec and drawings are provided to the contractor, and he's got to provide a price on that basis. If fluctuations apply, then you'll also have the schedule that incorporates the fluctuations. But in reality, you know, very few contracts these days have the fluctuation provisions retained within the contract. It's actually a very important area at the moment, considering you know, levels of inflation that we're experiencing, and particularly in relation to construction activities. And it's, you know, obviously from an employer's point of view, he doesn't want to have to deal with the increased cost, and you know, that would arise through the fluctuation clauses. You know, it's difficult for the contractor, but I mean, you know, most contracts would say that you know, that the rates are fixed for the duration of the contract. What happens beyond that, then, you know, if the contract goes beyond the original completion date, it just depends on the operative clauses within the contract. Obviously, in such circumstances, you'll be looking at delays, and ultimately you've got to get to the bottom of who is responsible for the delays and whether such delays will qualify as a relevant event and a relevant matter, in order to try and recover any additional time and money associated with those. But look, as I said, in relation to fluctuations, yeah, they're confirmed in the schedule as to how they operate. But as I said, you know, there's very few contracts kicking around these days where the fluctuation provisions have actually been retained. Okay, moving on. So I suppose the you know, the key area that we want to discuss in some detail today is obviously in relation to design. You know, DB, we're dealing with a design and build contract, and look, the DB contracts, in my experience, they, you know, they account for probably 50% of the contracts that I come across, if not more. So, you know, the principles are very, you know, they're very important for, you know, for the contractor and the employer alike to grasp. So from the outset, so the intention is that the employer should set out the requirements in whatever degree of detail is considered appropriate within the employer's requirements. The contractor should respond to these with the contractor's proposals, setting out the manner in which it proposes to design and construct the works. So, I mean, relatively straightforward, but, you know, the key, you know, to look out for the defined terms here is the employer's requirements and the contractor's proposals. It's very important that, you know, that such documents are in fact clear, that they are listed in the articles that begin in the recitals, actually at the beginning of the contract, and that it's clear to everyone, in fact, you know, what is included within the ERs, and as well as that, what is included in the CPs. Okay, depending on the procurement approach adopted, the level of detail within the employer's requirements may vary between a performance-oriented statement of objectives and a detailed and prescriptive statement of what the contractor is to provide. Similarly, responding to the degree of detail within the employer's requirements, the contractor's proposals may contain the results of substantial design development work, or may simply be a reiteration of the employer's requirements, can be referred to as a design and build approach. And now, just on procurement, you know, I come across you know, when you're dealing with DB contracts, I mean, the best approach that I've used in the past has been, you know, using a two-stage tendering approach. I think it's very difficult under a design and build contract to get everything right on a single stage methodology, because it's basically very difficult to get the information perfect first time around. And I think that's one of the benefits that is provided to employers when they adopt a two-stage approach, because they actually get the feedback from the contractors as to where there may be some deficiencies, or where there may be some information missing in the first round of tendering. Obviously, from the employer's point of view, he doesn't need to go back to all of the parties who tender at the first stage, particularly, usually where the price is simply not in line with the other prices which the employer may have received. So, design and build, definitely this two-stage approach I've seen has worked very well. From an employer's point of view, you have the benefit of the feedback from the contractors at the first stage, and you also have a design team who are starting to get more familiar with the project and develop the reasonable level of information that is required to build the project successfully. From the contractor's point of view, he's getting more familiar with the project also. And again, he's just getting a better chance to get his price right first time. I've been in a situation where we've had a design and build contract on a single stage, and basically where the employer just took the cheapest price. Such projects are difficult because from the outset it's almost doomed to fail, really, because what you have is an employer who has an expectation of a project to be brought in accordance with the cheapest price, and as we know, cheap more often than not works out to be expensive. And in such circumstances, you're going to, the employer is going to have a contractor who is motivated to try and recover any cost that may not have been taken into account in the original bid, or perhaps the bid was just ultimately too low. And from the outset, that's going to be a difficult project for everyone involved. So definitely, when I talk about procurement approach, I'm definitely an advocate of the two-stage approach when it comes to setting up what we all want to see, which is a successful contract for a successful project. That's what it boils down to here. So yeah, definitely D&B, you want to be going two-stage rather than single stage. Obligations. So the contractor's obligations, as initially set out in Article 1, are further developed in Clause 2.1. These include the completion of the works and their design. Under DB, the contractor is prohibited from undertaking any work for which it is necessary to produce design documents until such time as he has complied with either the design submission procedure set out in Schedule 1 or such other requirements as are stated in the contract documents at Clause 2.8. Where Schedule 1 is applicable, if the contractor fails to comply with the procedure, then he is not entitled to be paid for the work so executed. And then you can check paragraph 6 in Schedule 1. Now that's that's in relation to where obviously design has been rejected by the employer or the employer. And we talk about the employer, we talk about the employer's design team also. Well, I mean, based on whatever novation agreements have been agreed and applied to the contract. But obviously, for the employer to reject any design, he's got to have been given the chance to actually approve the design in the first stage, and that's the contractor's responsibility to commence that process. So the Schedule 1 design submission procedure, it's where the contractor submits the design documents to the employer. The employer returns design documents to the contractor marked A, B, or C within 14 days. If the documents are marked A, then that means they're approved. If they're marked B, then the employer has made comments. Or if they're marked C, then then basically the design documents have been rejected and the contractor is required to resubmit. Note that where the contractor disagrees with the employer's with the employer's comments, then he must submit his own version of events within 7 days, explaining why he disagrees with the employer's comments. It's actually, this is an important procedure in design and build contracts, which is followed, but from my experience, a lot of people are not aware of it. So, do bear in mind that procedure is actually very important and a key, I suppose, a key way to manage design throughout the course of the contract. So what is the design standard? Okay, so the contractor is required to undertake any design work to the standard expected of an appropriate professional consultants, such as an architect or consulting engineer, appointed directly by the employer and not undertaking any construction work. So that's basically, the design standard required from the contractor is the same as the employer would expect from, an architect or a consultant engineer, or if there's M&E elements, a mechanical electrical engineer, whatever, the contractor is required to meet the same standards as those other independent professional consultants. So the common amendment, so we're now dealing with basically the operative, design clauses, which they're contained from about, it's clause 211 to 218 within the DB form. So a common amendment is that in completing the design for the work, the contractor is not required to take responsibility either for the contents of the ERs or for verifying the adequacy of any design they contain, which is clause 211, save only to the extent that they conflict with the statutory requirements, which we'll deal with below. Now, I mean, the unamended DB form says that clause 211 says the employer has prepared the ERs, and basically the contractor is not responsible for the design contained within the ERs. And again, that is, that's a classic ground for amendments, in schedules of amendments, because obviously the employer is trying to allocate the risk for the ERs to the contractor, which is allowed to do, providing, so it's basically putting the onus on the contractor to understand what is in the ERs, and basically take the responsibility for them. Main reason for that is because if there's anything that's inaccurate in the ERs, then what the employer is trying to do is deny the contractor a variation for any such inaccuracies. So it's, this is common ground for amendment, because obviously the ERs are prepared by the employer. The schedule of amendments to the DB contract is prepared by the employer. The employer is trying to protect its own commercial interests, and as a result of that, he's trying to move as much risk onto the contractor as is possible. Really, obviously, it's for the contractor to be familiar with the risk and to protect its own interests accordingly. Also, so some case law in this area is this provision is intended to counter the possible implications of the 2002 case of Cooperative Insurance Society Limited versus Henry Boot Construction Limited. If, however, the contractor does identify a deficiency in the ERs and that deficiency has not been addressed by the contractor's proposals, then the employer's requirements are modified accordingly, and that modification is treated as a change. Now, that's basically a deficiency in the ERs which is not addressed by the CPs, becomes a variation, and that's what clause 2.12 says also. So yeah, you can see what's going on with the operative clauses in the within the DB form itself. Another case in this area was the case of MT Hogarth versus Eon Climate and Renewables UK, which is back in 2017, which is actually a Supreme Court case. So in a unanimous decision here, the Supreme Court ruled that MT Hogarth was liable for breach of the fitness for purpose obligations, which are construed either as a warranty that the foundations would have a minimum service life of 20 years, or alternatively be designed to last for 20 years. So in this case, MT Hogarth were the contractor. They were basically building wind turbines, actually, and a clause in the specification said that the wind turbines, when completed, would have a minimum service life for 20 years. They built the turbines, but obviously they failed before the 20-year cycle expired, and basically that was considered to be akin to a fitness for purpose obligation by the court. And ultimately, the contractor was responsible for the costs associated with building wind turbines that lasted for 20 years, effectively. So I mean, it was a very onerous position for the the contractor. But I guess what it teaches us is that you know, the contractor is going to be very familiar with the risk that he's signing up to in his contract. In this case, I mean, for, you know, the court to employ a fitness for purpose obligation, you know, obviously that is pretty much, that is the highest standard that the contractor can, or any designer for that matter, can owe to the employer. You know, usually when we're talking about design standards, we're talking about reasonable care, you know, reasonable skill and care, largely in line with the you know, the Sale of Goods and Services Act 1982. But here we have a fitness for purpose obligation, you know, which we don't see quite a lot of in industry. The reason why we don't see it a lot is actually because, well, one of the reasons, I guess, is that you can't actually obtain insurance for fitness for purpose obligations. You know, so if a contractor does come across what appears to be a fitness for purpose requirement, you know, then it's got to be very careful to make sure, I mean, that, you know, that it's, you know, comfortable with taking on that risk. But I mean, really, you'd want to be reducing the standard down to a position that's in line with your professional indemnity insurance. If you have a gap, say if the contractor takes on a fitness for purpose obligation, but it only has insurance for reasonable skill and care, I mean, the contractor is basically like, that's going to be a balance sheet risk for the contractor, because he's not going to have a policy of insurance to call upon in the event that there's an error in his design. So an area to be very, you know, for contractors to be very careful of, and also just, you know, sends a reminder that contractors just have to read their contracts and be very familiar with what's required. You know, turning around at the end saying that they didn't understand the risk, or that that's not what they thought they were signing up to, just won't wash. And you know, you don't want to end up in a situation like MT Hogarth did here, where they were ultimately found to be responsible. So very important case. It's not that old; it's only 4 years old, but it's definitely just in line with the position that, you know, contractors need to be very familiar with what their contracts actually say. So another area in relation to design is actually a license to use and the area of copyright. So subject to all monies due under the contract having been paid to the contractor, the employer is granted a license to use the contractor's design documents for any purpose relating to the works, although the copyright in such documents remains with the contractor. That's clause 2.38. Yeah, again, this is an area which is commonly amended. Some amendments don't even require all of the money to be paid by the employer to the contractor, and the other amendments see the employer doesn't get the license. He actually owns the copyright, because what the employer doesn't want to happen is just to have a license to use, and then, you know, later on down the line discover that he actually needs to have the copyright in the documents for whatever reason, because the contractor is basically, you know, I mean, he should give them over easily, but he's, you know, he's going to follow his contract. I mean, if he doesn't have to, he probably won't, and he's going to want to be paid as probably a sum of money in order for the employer to get the copyright at a later date. So again, another area that's starting to become you know, more and more contentious actually, is that area of copyright. So do be aware of, you know, of what the contract says. I mean, that's the standard form position, but as I said, it's an area that is commonly being amended in schedules amendments that we see at the moment. So conflicts. So yeah, conflicts basically. So conflicts and inadequacies in the ERs. So what happens in the event of a conflict or an inadequacy in the employer's requirements? I mean, the general position is that if there is an error, if there is an inadequacy in the employer's requirements, then the contractor, you know, will be, you know, should obviously report the inaccuracy or give notice of the inaccuracy to the employer. The employer is then supposed to review the inadequacy, give instructions as to how the inadequacy is to be overcome, and such inadequacy should be treated as a variation. That's what the standard form says. As I said earlier, it's an area that gets amended very frequently. So again, you just got to rely on what it is the contract actually says. Okay, what happens if there's a conflict or an inadequacy in the contractor's proposals? Now, so the contractor's proposals have been prepared by the contractor. The contractor's proposals are designed to basically set out what it is the contractor is going to build, in order to overcome any areas where the design may need to be fleshed out, or where more consideration is required. But basically, the contractor proposals, the responsibility for those documents will be retained by the contractor. So if the contractor has basically made an error in the preparation of the contractor's proposals, be it design, be it quantum calculation, any aspect, if the design doesn't work, such conflict or inadequacy in the contractor's proposals will be retained by the contractor. For the contractor to basically make good the contractor's proposals, he will not be entitled to a variation, and basically any remedial work will be required to be carried out at the contractor's own cost. So, obviously, I think that's a fair position. Reason being, I think if the contractor was entitled to a variation for errors in the contractor's proposals, then what you may come into ground where there could be some sharp practice where the contractor basically underestimates, could purposely underestimate the value of his contractor's proposals in order to effectively keep his bid artificially low. So I think I think that I wouldn't agree with that, because that's basically putting the employer on the hook. It's just basically kicking the can down the road, where the contractor is going to come back and say, yeah, my CVs aren't good enough, but I'm still entitled to a variation. That's not the position. And I think on the basis of that type of discussion, there's good sense to that. So what happens where there's a conflict between the ERs and the CPs? Now, this is the key battleground for variations under design and build contract. So like I was saying earlier, the key starting point here is to actually understand what it is, everything that's within the employer's requirements, and obviously then clearly list everything that's within the contractor's proposals. Where there are conflicts, there can be conflicts, but a lot of it will mean there's no need for any additional time or money. It's often the case that the conflicts exist, but they don't make any material difference to how the contractor is going to build the project. Obviously, here we're looking at material conflicts, which obviously will have a bearing on the contractor's price and program. So where there are conflicts, basically, if the conflict is in the ER's standard position, is in the is that the contractor will be entitled to the variation. Error in the CPs, as I said above, is the contractor won't be entitled to a variation for any errors that may be present in his contractor's proposals. Conflicts between the ERs, then, where this gets complicated is what happens if the CPs are wrong, but that's as a result of as a result of an error that was originally included in the employer's requirements. Now that basically requires a detailed analysis of working through the documents to see exactly what has been almost the root cause of the error, effectively, or the inadequacy. Because what happens in the situation where the ERs are wrong, but the CPs could perhaps be wrong even to deal with the ERs that were submitted. So the contractor's proposals may not have been adequate for either if the ERs were correct or even when they were incorrect also. So this is where it gets very confusing in relation to just trying to unpick. I suppose what you're trying to get to is the root of the problem. Because obviously when these situations arise, you've got a contractor who is looking for additional time or money, and you've got an employer who's saying that my documents, were right, or you shouldn't have you were wrong to make such an assumption, or you never clarified the situation. And again, it's DB contracts. This is the battleground. It always bears out in the facts. So it's very, but it's always an area that is rife for variations. When dealing with DB contracts. Okay, moving on to statutory obligations. So as regards statutory requirements, a term which includes development control requirements, the contractor is required to carry out and complete the works in accordance with them, including giving all necessary notices, except to the extent that the employer's requirements specifically state that any part of those requirements comply with the statutory requirements. So yeah, you got to deal with statutory requirements. I think that's clause 217 in the the DB form. The standard form is, we'll come on to it now, but I mean, if there isn't a statute updated during the course of the contract, the general position is that does give rise to variation, which we'll come on to. Conflict. So where there is a discrepancy between the employer's requirements or the contractor's proposals and the statutory requirement, then the contractor is required to propose for the employer's agreement and amendment, and then complete the design and construction of the work in accordance with that amendment, and entirely at his own cost, entirely at the contractor's own cost, except where the following provisions apply. So if there's been changes, so in the event that the statutory requirements change after the base date, such as to require an alteration to the works. I mean, a lot of people ask, why do we need a base date in the contract? And the base date largely relates to, to the updating of the statutory requirements. So you will see that most base dates tend to be in and around when either when the contractor receives a tender inquiry, or maybe sometime before the contractor actually starts on site. It's actually important just to understand that base date, especially lately in relation to statute changes such as obviously Brexit has been there has been statutory amendments there, so you really want to be careful about what the base date is included. In terms of, the employer will want to, backdate the base date as much as possible. Obviously, from the contractor's point of view, the closer it is to the start on site, the better. The contractor's proposals require modification to comply with the development control requirements, which means the statutory provisions which control the right to develop the site, unless the employer's requirements say that such matters are at the contractor's risk. And this provision is intended to recognise the fact that if the contractor is appointed before full planning permission is obtained, there may be unforeseen conditions applied by the planning consent. So, yeah, if modifications are necessary due to potential changes in the planning permission where additional conditions may be included, if a modification is required as a result, the contractor will generally be entitled to a variation, which does make logical sense. Finally, where it is necessary to alter any part of the employer's requirements, which the employer has expressly stated to be compliant with statutory requirements. So again, in such circumstances, the contractor will be entitled to a variation as a result. Okay, that's it with the design. With the design section, we're moving on to the final section now, which is this, I suppose, this principle, the inclusive price principle. So it frequently occurs in practice, and particularly in engineering contracts, that unexpected difficulties are encountered during construction, which may not only necessitate a change from the expected method of working, but in extreme cases may mean that completion of the work, at least in strict accordance with the original design, becomes impossible. So basically, what we're saying here is that construction projects are difficult. It often arises where there's the project becomes more difficult than what it was initially thought at the outset. What the inclusive price principle is saying, that largely in such circumstances that the contractor will be responsible ultimately. Now, obviously, that is predicated on the fact that the contractor hasn't adequately reserved their position, or they haven't actually made it clear as to what their intended method of working is. And I used to find, that schedules of clarifications included within the contract documents were very useful in order to just clarify what it is that we were assuming as a contractor. And obviously, what you're doing there is making a clear statement in order to rely on it in future if any changes are required, and it will obviously make it easier then to substantiate any any additional time or money applications. But this is basically where the inclusive price principle, and it's just it's like a school of thought really for contractors to get their head around when dealing with design and build contracts. So many contracts contain express provisions making such risk or contingencies the responsibility of the contractor. These can take the form of, for example, express disclaimers as to the state of the site and physical conditions or dangers generally, and also provisions for the protection of the work during construction. Now, this is very important actually in relation to the area of ground conditions. I suppose most design and build contracts will actually state a position in relation to ground conditions. NEC actually has stated a position in the compensation events. Obviously at section 60, JCT is silent on ground conditions. Hence why you see a lot of JCT schedule of amendments actually directly deal with the ground conditions. And obviously, again, as I was saying earlier, schedule of amendments prepared by the employer, he's going to look to make the ground conditions a responsibility of the contractor, and that's invariably what most clauses state. Also, another clause that's included is a reliance clause. So basically, where the employer has basically gone to a ground specialist or a geologist. They may have completed some boreholes. They may have completed a borehole log. The employer will provide that as part of the requirements, but in the contract, the employer would say that the contractor can use the employer's requirements, which include the ground condition schedule, but he's not entitled to rely on it as a method of working, and or that basically the employer doesn't give any warranty as to the accuracy of that information. So what happens then is that if the borehole logs, often it's the case, you could have a huge site, and sometimes the borehole logs are just completely inadequate. You may only have 2 or 4 borehole logs for a huge site. I mean, basically because that it's obviously a cheaper method to do it initially at the outset if the employer wants to try and keep the costs down. But what the employer is saying is that I'll give you the borehole logs, but you're not entitled to rely on them, and if they turn out to be inaccurate, then basically it's still your risk. So very important in relation to the area of ground conditions is again the clarity around the employer's requirements and the contractor's proposals, but especially those employer's requirements. And that no reliance. Another clause is the no reliance clause, where basically the contractors or the employer is saying that you can't rely on it. I'm giving you the information, you can use it as you wish, but there's no reliance. You can't rely on the information or rely on the fact that if it's wrong, that you're entitled to a variation. Again, just all setting the scene for the contractor that unless he adequately reserves the position, he's going to really struggle to get his variations or applications for time off the ground. So again, it's just another warning to contractors. Okay, in the absence of an express disclaimer, an owner who uses a professional advisor does not warrant that completion according to his advisor's plans of design is practicable, and that even in the absence of express provisions for the protection of the works, the risk in regard to the safety of the works remain with the contractor until such time as they have been reoccupied by the owner. So again, unless the unless the contractor has adequately reserved a position, even the safety, even the protection of the works, obviously, will be retained. The responsibility will be retained by the contractor. Nor does the owner warrant that he is competent in any way in making decisions as to the contractor's method of working. And this happened in the case of Neodocs versus Swinton and Pendlebury Borough Council. Excuse me. Now, in that case, basically, Neodocs was the contractor, Swinton was the council. Swinton had an engineer who basically told the contractor, not instructed, I guess, he basically told the contractor that he had to work in an alternative way. The contractor obviously, made an application for additional time or money. He wasn't successful because the alternative method proposed by the council's engineer was completely reasonable in the circumstances. And really what, the contractor, it wasn't for the contractor basically to decide what his method of working was after the event. If the contractor was, felt that the method of working was so important to them, then they should have clarified that in the contract. Had they done so, they would have been entitled to the variation. But as the contractor had not reserved his position, and the council's engineer stating that the work had to be built in a perfectly reasonable manner, then the variation wasn't triggered. So again, what it's saying is that for a contractor, you have to make your position clear, rather than trying to, I suppose, concoct a position after the event has happened in order to try and claim additional time or money, which is unlikely to be successful. So effectively, therefore, a contractor who, as is almost invariably the case, expressly or impliedly undertakes to complete the work or project according to the contract drawings and design, thereby impliedly warrants his ability to do so, and if he cannot, will be liable in damages. This is what we're coming back to in relation to the design and build contract. That's the position. You're saying you can build it for that. If for any reason there's a deficiency in there, which is not the responsibility of the employer, then that's what you're signing up to do. In consequence, any additional work necessary to achieve completion must be carried out by him at his own expense if he is to discharge his liability under the contract, and will not qualify for additional payment as a variation, even if he has been formally instructed to do the work in question. So again, inclusive price principle, it's, for the contractor, it is another warning that you got to get your price right. Obviously, you got to reserve your position in the contract as much as you possibly can. You got to make it clear what your method of working is. You got to, with design and build, it's significantly more onerous on the contractor than, say, what the position is under the normal standard building contract, obviously JCT form, which we're talking about today. Finally, I think it follows that every invitation to tender a price for the construction of a project to a design provided for or on behalf of the owner is in essence, therefore, a double question by owners to contractors. It's basically asking, can you build to this design? And if so, at what price? I mean, this goes back to the case of Tharsis Sulphur versus Copper and Copper versus McElroy, which is, it's 140 years ago now, but it's still good law, and it still asks the right question. Failure to do so by the contractor, even if impossible, can place the contractor in breach of contract. So, yeah, I'll leave contractors with that cheery note. Basically, you got to make a position clear, understand what's in your contract, know what you're signing up to, and manage the risk accordingly. Okay. So that's it, guys. We're going to conclude there. So I think we had some pre-submitted questions. We've plenty of feedback here as well. So yeah, so I'll take the questions now, Julie. Okay.
Okay, no problem. Let's start with the ones that are up on the screen, Connor. And the first one that came in was actually in the chat box. Someone saying that they currently have a contractor who believes they've shed their design liability by the client attending a meeting to review a route for a cable route and having a discussion about how it should be done. So the question is, under JCT D&B, is there a mechanism for the contractor to be relieved from the design responsibility by the client discussing the design? Person's presuming not. but equally, is there a way this could be done? I.e., is this the only way this could happen? The only way this could happen if the client issues an instruction to remove design liability for a portion of the work, and therefore, if it hasn't happened, then liability remains with the contractor. It's quite a complicated one there, but I think you get the.
Yeah, I get the gist of it, Julie. Yeah, yeah. But look, basically, the employer can agree. You know, if the employer agrees to, you know, take the design responsibility back from the contractor, then they can do so. But that needs to be under a variation, which obviously will amend the original contract agreed between the employer and the contractor. I mean, just because of a discussion that's taken place, that wouldn't seem to be adequate in order to absolve the contractor from the design responsibility. So, you know what I think it's clear saying here is that, yeah, you know, you can't, you know, the discussion alone would be inadequate, obviously, unless it's been recorded or there's been a follow-up email and, you know, the parties have agreed something, and it's not title variation. What they should do is basically, you know, agree an instruction or agree a variation to the original contract, if the employer wants to take back the responsibility for the design, you know, which may apply in the circumstances. But look, you know, there is a contract, there is an agreement. If they want to amend it, they're free to amend it, but it has to be by clear agreement between the parties, either by way of a variation or an instruction. That's pretty much, they're the most common ways. Obviously, it can depend if the contract caters for further grounds than that. Okay.
Okay. Something else here is saying there's two questions from a subcontract perspective on a JCT D&B 2016. The difference between completing the design and doing the full design, e.g. on a large subcontract, they only have one item as full design, the rest of the project as complete the design. Is there actually any difference in reality?
Is there a difference in reality? There is, because you know, it's almost a play on words to some extent, but full design means that you're basically starting design from scratch, from the beginning. You know, I would read a full design as that, you know, very little of that design has actually been completed yet, and that the contractor or the subcontractor is entitled to complete the design process from start to finish. That would be my own interpretation of full design. You know, compare that to complete the design. Complete the design, you know, implies that some element of the design has actually been carried out. And what the contractor or subcontractor is being asked is to actually, you know, finish off that design. But in essence, to actually do that, a contractor, subcontractor is actually should be checking whatever design has been complete. So in effect, he's almost having to complete the design from the very beginning anyway. But it's easier to actually check that other design rather than it is to you know, come up with a completely new design from inception. So, you know, there's little. I mean, there is a difference, but, you know, is it material? Not really, because full design, you got to start from the beginning. Completing design, really, in order to do that properly, would require a review of all the design that has been carried out from the beginning, and obviously then completing whatever elements need to be fleshed out, in order to come up with what we're looking for, which is a complete design. So yeah, so that's how I deal with that.
Okay. Second part to that person's question is, if a product is in the specification and we use that product and it does not meet requirements, who is responsible? I.e., who is responsible for the design of a proprietary item of specification? The example that's given here is a fire hatch off the shelf. However, the fire test data has inconsistencies versus how the product is being used on the project, and as such doesn't comply. And this person is saying they suspect this remains with themselves regardless if it's specified. Is that so?
Yeah. Thanks for it's a very specific question, but we can work through it. if a product is in the specification, I mean, what this sounds like is actually, if it's in the specification, if the specification is an employer's requirement, then this sounds like, an inadequacy or an error in the employer's requirements. And if that is the case, obviously, depending on the wording of the contract, then generally, if there's an error inadequacy in the ERs, then the employer retains responsibility. Well, I mean, what should have happened here is, the contractor should have should give notice of the fact that the product didn't meet the requirements, because that's clearly a conflict, and there are notice provisions which require the contractor to do so. So basically, the contractor needs to be, really should have commenced that notice procedure in order to give the employer the choice to see whether they still wanted to go with the product specified in the specification or with an alternative product, or how the issue was to be overcome. So it looks depend that example would depend on the, I suppose, on the facts and how it has unraveled. I mean, contractors have to be very careful. Even if they think there is an inadequacy in the employer's requirements, they still have to give their notice and follow the notice provisions under the contract. Otherwise, you could be accepting that as acceptable, only to find almost becoming a contractor's proposal, and the risk is that the employer turns around afterwards and say, no, that's not what I wanted. And if that's the case, then the contractor is going to find it very difficult to unravel it and come up with a solution, really. So again, it's a case of reading the contract. It's a case of following the notice provisions, understanding what the root cause of the issue or the inaccuracy or the error is, and dealing with it. Like, the contract provisions cater for all of these circumstances. So it is a case of pulling out the contract and following whatever procedure it specifies. Okay.
Yeah. Okay. Another question here on the Q&A box. This obviously, it's not a three-part question, but there's obviously three parts to the thing. If the requirements for best practice as opposed to statutory requirements change between the date of tender and the contract date, who is liable for the costs of any improved specification? And they then further clarify what they're thinking of as a situation where you're building an operating theatre or a process area in a pharma plant, and the HVAC standards improve, apart from the additional cost of the better quality equipment, such as duct sizes, such things as duct sizes and weight can change also. So who's liable for those costs?
Right. So if the requirements for the best practice change, as opposed to the statutory requirements, I guess it changed between the date of tender and the contract date. Who is liable for the costs? I mean, my own thinking on that would be that it would be the contractor who is, the onus would be on the contractor, to bring the change to the attention of the employer, particularly where the best practice, where best practice hasn't been updated by the employer per se, but it may just be an industry best practice, which the contractor is going to be best placed to he would be like, I mean, if we're talking about pharma plants and HVAC systems, the contractor, the M&E contractor in those circumstances, is likely to understand those, I suppose, the industry practice, and if the practice regulations have actually been updated between the date of tender and the contract date. So I think there is an onus on contractors, especially in the area around specialist contractors. I mean, that that the contractor is employing a specialist to come up with solutions to what are complicated elements of any project, especially when we're talking about M&E. So I think it's I think in this situation, I would expect the contractor to be raising it as an issue, because I think conversely, if he doesn't and he knows the situation you know, he knows that the practice regulations have been updated and improved, which will cost, you know, I mean, when practice regulations get updated, it basically means to become more, generally means that to become more expensive for the contractor to work in accordance with. So, I mean, if a contractor signs a contract knowing that the best practice regulations have been updated and tries to rely on that as a and is expecting a variation for it at a later date, I think he might struggle. I think the contractor is putting himself in a difficult position there, and I think it's somewhat unfair on the employer to kind of be set up in such a way also. You know, that and the employer will obviously be asking, well, you know, why didn't you tell me about this at the time of contract? And we could have agreed it. You know, we could have agreed it there. So look, I mean, obviously, I don't know the exact circumstances here. It's obviously quite a specific example again, but I would be expecting, and again, you know, we talked about the inclusive price principle. I mean, the contract would say that the contractor is required to work in accordance with the, you know, with the industry regulations and standards that are present at the you know, pretty much at the time of contract again. So, you know, I think if there is such a clause in there that states that, you know, again, all the more reason why the contractor is going to struggle to try and recover any additional money as associated with working in accordance with the best practice regulations that have been updated. So I hope that's given a guide as to how to answer the question. You know, best practice, obviously, it goes back to as well, that's unlikely to be a change to the statutory requirements. I mean, statutes don't get updated to deal with like HVAC systems or specific M&E items. You know, what we're really looking for here is industry best, like what we're seeing in the area of cladding at the moment. Obviously, the cladding standards are getting updated because, in reality, probably, you know, prior to Grenfell, they probably, you know, they were probably inadequate, really. You know, who takes the risk with that? Again, it's a case of reading the contracts. You know, specialist contractors being open about, you know, whatever the updated regulations say and pricing accordingly. You know, I think that's you know, that's how it's got to work. Unless you agreed something to the contrary, unless there's an agreement to say that they'll deal with it later on. But I think the first step is that the contractor should be bringing it to the employer's attention at the time of contracts, and again not pushing it down the road and hoping to use it as a variation at a later date. I think that's a risky strategy for a contractor, and I think it's kind of unfair for an employer to be put in that situation also. Okay.
There's just two more quickly. How often do you see a guaranteed maximum price amendment in DB contracts? In your opinion, what benefit does this truly bring, given that the person who's writing understands this is still subject to amendment through variations under the contract?
Yeah, guaranteed maximum price. And my experience is that guaranteed maximum price in JCT D&B contracts is very rarely used. And I think, you know, go back to what I said earlier about, you know, risk allocation. Design and build contracts are inherently more risky for a contractor. That's what they intend to do. What an employer is saying, I need a building and I want a contractor to design and build that building for, you know, for a price. But, you know, the contract sum is generally, you know, sufficient, you know, for the employer. I don't see the guaranteed maximum price being used. I've actually not come across it myself, to be honest with you, using a guaranteed price mechanism, and I think that's reflective of the nature of the risk involved in the DB contract for the contractor. I mean, if a contractor is signing up to a DB contract and is then signing up to a guaranteed maximum price, I mean, I'd be worried about a contractor's due diligence in those circumstances, unless he's got, you know, it's like a very high contingency built into the price to deal with any changes that might arise from design changes. Because if he hasn't, I mean, he's making his position very, very difficult in order to try and make that contract commercially viable. So, and I think that the GMP hasn't been brought in to the design and build context, because I think there's an industry recognition that the design and build contract is almost risky enough for the contractor without adding in another layer of complexity that surrounds the guaranteed maximum price. I think also it has to be recognized that where you're dealing with a guaranteed maximum price, that if a contractor is willing to sign up to that, you know, it either means he doesn't really know what he's doing, or he's got a very high contingency within the contract sum to deal with. I think they're the two common factors. And from an employer's point of view, I think in both circumstances, alarm bells would be ringing, because why would he want to contract with a contractor, one that doesn't know what he's doing, or on the flip side has a lot of money built into his price as a contingency? You know, I'd sooner play a straight bat with the D&B contract and just deal with the variations as and when they arise. Look, obviously, if a contractor really wants the GMP, then, you know, you can obviously request that from the contractor, but, you know, be aware that that will come at a price at some point in time. You know, look, there's variations in the contract, but the GMP, I don't know. I don't think it's used because it doesn't make a whole lot of sense when you look at the makeup of the design and build contract and how it's trying to allocate risk between the parties at the outset. So that's how I'd answer that one.
Another one here. If stage 4 drawings have been included in the JCT D&B contract as both the ERs and CPs, and the contract has been signed by the client, is this deemed drawing sign-off, or are you still required to reissue these drawings under Schedule 1 and then the client issue it as status to achieve formal sign-off?
Stage 4 drawings included within the DB contract itself. I mean, if they're issued as construction, I mean, obviously at the time of contract they will be you know, tender drawings, or, you know, so I mean, if the same drawings are issued, which is very rare, to be honest with you, that there would be absolutely no change between the tender drawing and the construction issue drawing. I don't see. I mean, you should still, from a contractor's point of view, you should still check it with the contractor. Does he need to go through the formal process of the design submission procedure under Schedule 1? He probably should, really. He probably should, just to be safe from the contractor's point of view. But I've actually never come across a situation where there's, you know, stage 4 drawings in the contract that had no amendment whatsoever at the time of construction. I think if we did, I think if that was to happen, we wouldn't need construction solicitors, because there wouldn't be any gray areas. So, you know, from a contractor's point of view, I think to be safe, go through the design submission procedure. I still think that's just good practice anyway. And from a contractor's point of view, that, you know, if you do that and there has been no changes, then you're perfectly protected and just get to work, you know.
Yeah. The last one that we'll take for today, it should hopefully be a quick one. You talked earlier on about hierarchical list of documents in the contract. Does therefore one document take precedency over another in order of the list?
Yeah, good question. Good question. So, I mean, I think it's clause 1.3 of the JCT design and build contract says that the contract is to be read as a whole. But what you see, so that, I mean, that basically means that there is no effective hierarchy in the documents or structure of the contract. But what invariably happens through these schedule of amendments is that the hierarchy clause, you know, does get included, and the hierarchy is very clear as to how the contract is to be interpreted. The hierarchy again is there so that for the employer's main documents to be listed at the very beginning, because if there is a conflict between the hierarchy deals with a conflict. If you have a conflict in a document, say document 1, between document 1 and document 10, then what the hierarchy clause does is say that document 1 will basically take precedence over document 10. And that's the reason why you have the hierarchy clause. It's basically the case that you just have to read the contract and understand, the interpretation of the list of documents that are being included in the contract. I used to have many discussions about this as a contractor because I'd want my schedule of clarifications at the very top of the hierarchy. Obviously, because that's the strongest position, because in that situation, excuse me, in that situation, if I've stated anything in my schedule of clarifications that conflicts with anything that's in the documents prepared by the employer, well, then my schedule of clarifications will prevail. Heavy days for a contractor. It was always difficult discussions, but and you'd always reach a position that was acceptable. But it's just a case of understanding, looking at when we talk about the hierarchy, we're looking at how will this contract be interpreted, and what documents will supersede others. And when you understand that, then you will understand the makeup of your contract, and you will understand what documents need to go where in order to adequately structure the contract in your favor, or to make sure that any of the specific agreements that have been made that are very important to the contract are towards the top of the hierarchy. Because if they aren't, if you've agreed a very important document, but that's listed at document 100, and you've got 99 documents that kick in before it, it basically means that the time and effort gone into agreeing that very important document is basically a waste of time, because pretty much everything will be superseded by the 99 documents that precede it. Yeah. So it's just a case of understanding how your contract will be interpreted. Okay.
Right, Conor, thank you very much for your time. I know we've run slightly over this morning as always, but it's just quite a busy session. So thank you for your time. Thank you to everyone for attending. We are next with Conor next week, where we have the latest in his QS series on project security. That's at 8 AM on Wednesday. And also tomorrow night, we have Mohammed Hack with the latest in his adjudication series, and he's looking at jurisdictional challenge. So if you'd like to book places on either of those, simply email juliecamp@silverllp.com or seminars@silverllp.com, and I will pop you on the attendance list, and you can see there if there's anything specific that you didn't want to ask in an open forum but is a burning issue for you. Conor's email address is on the screen, Conor Ahern @silverllp.com. He's always happy to assist. Right, Conor, without any further ado, I will see you in the office later, and good day everyone, and have a great day. I hope the rain doesn't ruin your parade too much. Conor, thank you very much. We'll see you soon.
Great, thanks Julie, thanks everyone.